Thank you, Chris, and to the entire Environmental Law Institute for having us here. This is a really fabulous series, and I remember, hopefully not that long ago, sitting where you are. It's a great series to, learn about the basics about these statutes, to get a refresher if you haven't seen them or dealt with them in a while, and it's certainly timely. So. Really appreciate it. Again, my name's Jamie Auslander. I'm with the environmental law firm of Berridge and Diamond. We're the oldest and largest law firm in the country, devoted almost exclusively to environmental law. And I'm sitting here with...
I'm Adam Crone. I'm with the Environmental Integrity Project. We're a nonprofit organization aimed at the enforcement and basically attempting compliance with federal environmental laws such as Clean Water Act, Clean Air Act, and our hazardous waste statutes.
Nice. Like attempted compliance.
Yes.
It's a really exciting time to be in this field. It's the law of what we're going to be talking about, the National Environmental Policy Act and the Endangered Species Act in particular, is not static. It's constantly changing, and now's a really exciting time to be practicing in this area. So really, glad you're here and encourage you to pursue your interests here. As a lawyer, I have to start with a qualifier. So I teach, for instance, a full day course on NEPA alone, and we're not going to be able to cover everything in the time we have here. We're going to cover the basics. You should be able to leave here to be able to, articulate what the statutes are about, issue spots, some of the key things, have a high level understanding of how to do these analyses. But the slides are really for you to take home and study. Just really encourage you to listen, participate, ask us questions. As Chris said, don't wait till the end. Really would like it to be a conversation. If something's not clear, we can give you another example of how it maybe applies. I'd like to do that. We will have time at the end, and so if we are getting pressed, then we'll move it then. But really, don't hold back. Really would like to. I don't know if you.
Yeah, no, that's all the same that I would have said. Basically, feel free to chime in at any point. These are complicated laws, and we've got, basically a little bit of time each, but anything you want more clarity on, feel free to ask.
Yeah, and if you don't get to it today, you can contact me or Adam anytime after us. Our information should be included, but you can get me at J. Auslander, AUSLANDER, at bdlaw.com.
And I'm A. Crone, that's AKRON, at environmentalintegrity.org.
All right, and we'll repeat those at the end. So why don't we just jump right into it? So it's, better appreciate today's topics. Why don't we take a step back in time? So remember when, okay? It's the 1960s. All right, nothing much going on, right? Everybody pretty sitting on their hands. The U.S. Average price per gallon of for gas is 35 cents. No one knows what a mobile phone is. Mobile phone is when you took your rotary. Remember that thing that spins? You tossed it out the window. And as this time's going on, there's a cultural movement, right? You got hippies, but ingrained in that was a rising of environmental consciousness, and that really stemmed from years and years of the Industrial Revolution, really focusing on economic development, but not really focusing on the impacts it was having on our environment. And so you had smog in cities, waterways being polluted, and so the environmental consciousness really took hold, and it started to manifest itself sort of in one-off statutes. The Wilderness Act was passed in 1964. A couple years later, an ancestor of the Clean Air Act was passed, but nothing really comprehensive. All right, so what do we do? How do we get the environment front and center, and we get legal requirements on the ground to consider and protect the environment? Well, as is so common, we have debate in Congress, but nothing really happens until you have a calamity, right? So it just happened with the VA. How long has that happened? Anybody watching Jon Stewart? That's his mantra. But now we finally have everybody, unanimous legislation because we have a scandal. Well, here, there's a couple other things that were going on then. Specifically, we can point to is the January 28th, 1969 blowout offshore Santa Barbara. It was an offshore oil and gas platform. And it impacted miles of California coastline. And that really, I think, coalesced action to get something done on the ground. And so later that year, and officially enacted in 1969, and I'm sorry, signed by of people, President Nixon in 1970. It was decided the best approach was to declare a national environmental policy, and that was passed in the National Environmental Policy Act that was signed in 1970, January 1st, 1970. And without such a policy, it argued that federal agencies just wouldn't consider the effects of their actions. They would just continue to do what they'd always done. So Congress overwhelmingly passed NEPA, and NEPA became known as the Magna Carta of environmental law. But environmental law, like potato chips, you can't just have one, right? So in rapid succession, we get the core of our modern environmental law framework. EPA is created in 1970. You get your first Earth Day, the Clean Air Act passed later in 1970, the Clean Water Act 1972, and then the Endangered Species Act 1973. Really was a different time. We're going to be covering some of these other statutes in later sessions, and I hope you come to them. Got some great speakers and experts on those areas. But today, Adam and I are going to focus on NEPA and ESA. Just sort of, we also have RCRA and CERCLA Superfund that we're going to cover later. Just to think one other background note, so we're all talking about the same thing.
So we'll be talking about various types of legal authority today, so it's kind of useful to go through and make sure we're all on the same page. Most obviously, we've got statutes and regulations, statutes enacted by Congress, the regulations promulgated by agencies interpreting those statutes or filling in the holes. Then above that is, of course, the Constitution, which basically, for the purposes of environmental law, provides a lot of the issues. You know, we've got takings under the Fifth Amendment. We've got the Commerce Clause, which is the basis for all these environmental laws, or sometimes, as the Supreme Court has found, not the basis. Then we've also got standing, which is huge for environmental plaintiffs. If you don't have standing, you can't bring a case. And then, you know, below that, we've got case law, which has its whole own hierarchy. You've got the federal courts interpreting the laws, forcing federal agencies to either change their actions or change their regulations. And basically, one of the bigger issues that's come about today in the recent era has been the use of guidance by agencies instead of rulemaking. And it's sort of getting into the area of, you know, how far can we go with just having guidance instead of rulemaking? Agencies sort of prefer guidance because it's not, you can't use it against them, but at the same time, it's you know, it's easier to get it out there, but it's harder to actually get anything done with it. So for those of you still in law school, definitely encourage you to take admin law and constitutional law. They're huge for environmental issues.
Yeah, I mean, you come in, I mean, I was a first-year associate, and I got a constitutional, a dormant Commerce Clause case, and, you know, like, well, I didn't really pay that close attention when I was in constitutional law, but environmental law is really an area where these things all come together. You see preemption under the Supremacy Clause. You see how, you know, the Property Clause, federal lands. What can Congress do? How can they dispose of their lands? And on guidance, you know, can you challenge it, you know, or no? You know, what is binding? Is the agency in practical effect really following that guidance, or not? And
right.
You know, that a lot of that is in the gray area, not just of environmental law, but administrative law. But environmental law is really where it rears its head a lot. So let's jump into the first of our two, you know, big topics today: NEPA, or the National Environmental Policy Act. And here's again what Adam was talking about, the hierarchy. You have the statute, you have the regulations, and the main regulations are promulgated by the Council on Environmental Quality, or CEQ, and that's stationed within the White House. It's not an independent agency, but it passes, its rules are very general, are supposed to guide agencies in conducting their reviews under NEPA. It also directs individual agencies to pass their own NEPA regulations tailored to what they do: transportation for roads and rail and transit, the Bureau of Land Management for oil and gas exploration, Department of Defense for defense contracting, and Army bases. All have their own individual NEPA regulations. Some of them are really detailed, and some of them just sort of parrot the CEQ regs. And then you have guidance, a whole bunch of guidance. NEPA just turned 40 years old. And so we had a whole bunch of guidance issued on how we can do NEPA better. Particular issues we'll get into about mitigating impacts, right? So what is mitigation, and then how binding is it on us, and how should we express it? How do we consider things like greenhouse gas effects when we're looking at individual projects, right? All these things are covered by guidance. They're not legally binding, but as a practical, you know, it's a practical matter. It's really dictating how the agencies are going to proceed. Here's a couple websites. Again, you can go and great bedtime reading. And one other thing I want to note, NEPA is not just a federal regime, so it also allows states to come in, and a lot of states have little NEPA laws. California, anybody from California? Okay, God help you, I'm sorry, but the California Environmental Quality Act, or CEQA, is its own animal, much more substantive than NEPA is, but that is the biggest little NEPA there is. And then a couple other states have, New York and a couple others, some pretty rigorous requirements that you have to understand if you're building a project in those states. So NEPA at a glance, as I just mentioned, it's about 40 years old. Dual goals, right? First thing, it's called the National Environmental Policy Act, not the Environmental Protection Act. Okay, what do you make of that? Any ideas? Policy, I'm going to call. Don't make me do this law school thing in the summertime. Yeah?
The environment can lose in the balancing of interest.
Exactly. As I mentioned, it was meant to codify a national environmental policy. So it's supposed to be I'm sorry. The answer was that I say it again because I think you said it better than I can.
The environment can lose when you're doing the balancing of interest.
Correct. So it's a balancing of interests, and the environment doesn't necessarily. You don't need to take the most environmentally protective action. You have to consider it, but you don't have to take it. So NEPA is not an action-forcing statute. It's a procedural statute. Consider. Look before you leap. That's really at the heart of it. And the idea, again, was if we think about environmental impacts, we're not going to, hopefully we will dispose of alternatives that have unnecessarily high impacts, and we will build our projects smarter and more environmentally sensitive. But sometimes we need a bridge, we need a road, and leaving a tree in place might be the better environmental thing to do, but we're allowed under NEPA to make the decision, even if it has hugely horrible environmental impacts, to pick that alternative. Can you always take it? No. Other statutes may force you to consider and adopt certain actions. So the first goal of NEPA is environmentally informed decisions, information. Make sure we know what we're doing before we do it, because after we build it, if we had worse impacts than we anticipated, sorry, it's built, right? Second major goal, which is related, is public transparency. So the agencies recognizing that they are the experts, but they're not the only they're not the only stakeholders. You also have the public. Local groups understand their resources better than anyone else, and so it's supposed to have public involvement, public knowledge, transparency, and decision making. And NEPA fosters that. As I said, no surprises, no regrets. But one thing NEPA is not intended to do is to have reams and reams and bury you in paperwork. Okay, it's supposed to enable smarter, better informed decisions, but it's not supposed to be a navel-gazing statute where you're paralysis by analysis. Okay, so keeping that basic framework, does NEPA apply? I got a question here.
It seems like it maybe comes later.
Yeah, we'll get to that question later, but I'll address it at the end. But thank you for the question. Does NEPA apply, right? And we can all get up and go because, well, if it doesn't, we don't really need to worry about what it requires. Really broad trigger, the magic language. Proposals for major federal actions significantly affecting the quality of the human environment. Okay, that's a mouthful. In effect, what does that mean? Any federal agency action that's discretionary in nature. So, if we're talking about approval, a BLM approval of a fracking well on federal land, that would be covered. The Forest Service adoption of a forest management plan, right? Federal action, that's covered. How about, giving federal funds to a highway project? Definitely. That's a federal nexus. Even if there's no decision-making power, there's a nexus. It's federal funding. How about the issuance of regulations, like for offshore wind or something? Definitely. Covered by NEPA. You have to issue NEPA for all of that. Okay? Where it gets a little bit hazy is when you break these down a little bit more. So a proposal, right? What is a proposal? Is it something in my head? How definite does a proposal have to be? What would be the problem if if the NEPA trigger was before a proposal had been sufficiently crystallized? Anyone? I'm sorry?
You can't act.
Right, you can't act. You just basically don't know the information. You don't know what you're evaluating, right? It's just, I need more transportation solutions. Well, what does that mean, right? You're not. You need to give me some context, exactly what you're doing. What happens, but if it's too late, right, then we've already taken the action. If it's too far crystallized, then our thinking about the environmental consequences won't affect the action because we've already predetermined what we're going to do. Right? That's a common charge against agencies when folks don't like projects. They change the agency, knew what it wanted to do the whole time, and this NEPA thing was just for show. Right? That's a common claim. NEPA's supposed to hit that sweet spot, right, where you have a proposal in mind, but you aren't sure exactly how you're going to do it. So breaking that down, a little bit. How about, for federal actions, right? How about I'm sorry, it's how about an EPA action that would be benefiting the environment? So how about, for instance, a Superfund site cleanup, where EPA issuance of certain registrations for products, they're supposed to be better than the ones before them, right? Those things wouldn't trigger NEPA because it's not federal agency action. So like the Keystone Pipeline that everybody hears about, actually NEPA is not really required for that. It's a presidential permit. The president is not a federal agency, right? But the State Department is doing the lead, and as a result, they've done NEPA on it. That's one thing we're going to do. You can always do more NEPA, right? You can't stop an agency from considering what it wants to do. So you always can do more NEPA, but is it required? Not necessarily. Eminent domain, like condemnation actions, right? Not triggered. And why? Because there's exemptions, sometimes in statutes, and sometimes courts judicially send in some exemptions. Under FIFRA, which is the pesticide law, for registrations of pesticides, the courts have held that NEPA does not apply to those decisions. Why? Because the statute says that you're supposed to consider X, Y, and Z in making those determinations, and you have to do it within a set period of time. And if you were going to layer NEPA on over that, which preceded the earlier statute, then basically you would make the requirements under FIFRA. You'd read them out. So it's a functional equivalence type of argument, and that's an issue that's, again, kind of floating around the courts in a few different areas. One thing where we're gonna kind of give you a little bit of a mind bender. What about an action, a designation of critical habitat under the Endangered Species Act? Does that trigger NEPA? Who thinks yes? Who thinks no? You're both right. It depends what jurisdiction you're in. The courts are split on it. So again, the idea, it's environmentally positive action. The courts who say NEPA isn't required and we're going to cover it in our ESA permitting. But the courts that do require it say, well, no, it's a major federal action. You need to do NEPA. Sorry if there's a little redundancy there, but you have two statutory requirements. One issue that's really coming into play is segmentation. So what if I have an action, I want to build a 100-mile pipeline, right? But I don't really want to trigger NEPA because it's going to take a long time and they're going to be built in different years. So what if I break it into like 3 30-mile pipelines? Anybody see a problem with that? Is that permissible? No, generally not permissible. The test is whether it has independent utility. Okay, so the D.C. Circuit just last week struck down this exact scenario where there was an upgrade of a pipeline that was proposed. It's going to be 40-mile, but it's part of a 300-mile system upgrade. And the court held that you had to analyze them all together. Right? So this is an area where, again, you think it would be settled, but it isn't. So in short, federal actions under NEPA are those potentially subject to federal control or responsibility. And it's possible, though very difficult, to tailor a project that would otherwise trigger NEPA so it doesn't. So who does NEPA? Who does NEPA? Well, a lot of folks, right? You have the lead agency. That would be your project proponent. Who wants to do the project? Who's behind it? Sometimes it's a private proponent, but who's going to be the lead approval on that action, right? So you may have a state highway administration that wants to build a project. That's a state agency, but federal highway needs to approve it. So federal highway administration would be the lead agency on that project. But again, they're not working alone. They work in an entire integrated system of federal agencies, bureaucracy. So You have cooperating agencies, and that could be federal, it could be state, it could be tribes, it could be local agencies that give special expertise. So I'm going to cross sensitive habitat, right? I need Fish and Wildlife. I need the state Fish and Wildlife Service to tell me what areas are sensitive, what species are present here, so they can consult with me. You're allowed to hire consultants. Okay, that's a common misnomer. No, you can't. Private. You need to have hands off with NEPA documents. Nuh-uh. I mean, there's a whole industry that's risen up to prepare NEPA documents. It's okay to hire them, but there needs to be agency supervision, and the agency ultimately is going to be responsible for the decision. So you can't pass the buck, but you can delegate. In this day and age of compressed budgets, that's really a big advantage. The private project proponent is obviously involved, and the public through commenting. Again, remember, public transparency. That's what we're concerned with. So the public is supposed to be involved throughout the process, and the earlier they're involved, the better. Now, what's the problem here? Well, the players don't always get along. They don't always play in the sandbox nicely, even under the same department, right? So if I want to have a resource development, I want to have oil and gas or mining or other kind of development on federal land, right? The Bureau of Land Management probably manages those lands, and it's a pro-development agency. That's its main, has several mandates, multiple use, but its main charge is to develop resources. And under the same interior umbrella, you have the Fish and Wildlife Service. And what's their main concern? Birds and bunnies, right? So where do they get together? Naturally, completely conflicting missions, and they somehow have to get to consensus.
And a little bit later, I'll be talking about a case I worked on for the purposes of the ESA talk, but you had multiple agencies, and you had the Federal Energy Regulatory Commission as the lead agency and a bunch of agencies under it, including the Bureau of Land Management. And BLM didn't love the EIS that FERC prepared, but and they sort of raised objections. FERC stood firm and changed a few things, but BLM ultimately signed on to it, and it was on them. So they got sued over it. It was as much their EIS as it was FERC's. So even though they weren't completely on board, that's just how it goes.
Yeah, and when we get into, and we'll have some time at the end for hot issues, but getting the agencies together, I mean, it's as simple as a failure of communication sometimes. And it seems so easy, but getting them in a room and getting them agreed on what the issues are up front is a huge time saver later. So it's totally not unheard of that a project goes through, and then at the last minute, the agency raises its hand. Says, whoa, you didn't consider this. Well, that really would have been nice to know at the beginning of the process, so we could have accommodated that. The sandbagging effect happens a lot, but it's not useful. There have been, even instances where agencies, certain staff, and they've gotten in trouble for it, have talked to plaintiffs, potential plaintiffs, local plaintiffs, and given them sort of insider information. I mean, this happens. And it's kind of mind-boggling, but it happens. It's such a big governmental system. So NEPA applies. Now what? Well, you can comply with NEPA 3 basic ways. All right, and you can prepare a full-blown environmental impact statement. You can prepare what's supposed to be a more streamlined environmental assessment, or you can utilize a categorical exclusion. We'll get back to these in a minute, but I want to focus on sort of in the first box, the other part of the test, significantly affecting the quality of the human environment. Well, what does significantly affecting mean, right? Well, what's significant, right? You can't say, you can't legislate that. It's totally case by case, but we're supposed to look at 2 main components, context and intensity. So context, where are we doing the action? You can't look at effects in isolation. You have to take a holistic view. So if I'm trying to build a shopping center, right, it's a 2,000 acre wetland and I'm filling 3 acres of it. It's sort of a different issue than if I'm dealing with a 6 acre wetland and I'm filling 3 acres of it, right? Different type of decision.
This might be a good place to answer that question.
The question was, can an EA or a checklist be required for an area that is not designated as environmentally sensitive or of cultural significance by federal or state records? Yes. The short of it is yes, because you don't know what's significant at the outset. If we all knew what kind of projects were significant and what weren't, we'd be fine. Actually, should have said this before, agencies in issuing their own regulations can put in a presumption of what kinds of projects normally trigger EISs and what kind of projects normally trigger EAs and what projects typically are categorically excluded. We'll get to what those mean. But the benefit is that, again, sort of up front, we can get some certainty as to what box we're in and how much, documentation is going to be required for
Yeah.
NEPA. But we don't know. I mean, we don't know. Just because it's not officially designated as a key habitat area, it may have significant effects under NEPA, and so you
Yeah.
have to do the analysis.
As you can see from Jamie's list under intensity, sensitive areas and cultural resources, they are part of the query here, but they're not the end of it. So, there's certainly other ways you can get there.
Right. So thanks. That was a good place to do that. So context, but also intensity. So not only where are we doing it, but how bad are our impacts? How heavy are they? And a couple of things to take away here. You have to consider beneficial impacts as well as adverse ones. So, again, it's not the National Environmental Protection Act, it's the Policy Act. We don't know. Even if we're trying to do something good for the environment, right? We're trying to do a site cleanup. Well, what if that's going to disturb, undiscovered contamination and re-release it into the waterway? We need to know up front so we don't have any unintended consequences. The other thing I want to point out is that agencies don't need to consider remote or speculative impacts. Okay, so this is really important. So we're talking about things like climate change, right? And if I'm building a road, I'm drilling a well. Climate change. How do I gauge the effect of that on global climate change? Climate change increasingly is becoming a feature of NEPA documents, and we encourage you not to just skip over it, but how you account for it and how far you have to prognosticate there's limits on that. You don't need to have speculative impacts. So we've talked about significance. Now, which effects are we talking about that might be significant? All right, it's a variety. It can be ecological. It could be aesthetic. It could be visual. It could be historic or cultural resources. And not by themselves, but when you're undertaking an action that's going to have environmental impacts, you also have to think about socioeconomics, right? So if I'm thinking about deregulating a genetically engineered crop for commercialization, right? I'm thinking about the environmental impacts, but I also should be thinking about, well, what's that going to do to the market? What's that going to do to acreage that's going to be dedicated to particular crops? What's that going to do to organic farmers? Those types of things are more and more being included in the NEPA analysis, and you exclude them at your own risk. Three main kinds of impacts: direct impacts, right? So this is, if you want to build a shopping center, you want to build anything, you want to build a house, right? If you're cutting down trees and filling in wetlands to prepare that, clearing that land, right? Direct effect. If I want to build a house, the direct effect is I got to cut down, I got to clear the land for it. All right, indirect effect. All right, well, it's caused by the action, but later in time. But it's still reasonably foreseeable, right? So I'm building a road. Yeah, I got to think about everything in the right of way, what I'm going to hit. But also, I should think about induced development. Right, I build a road, people are going to come live there. I'm going to have more commercial development there. I'm going to have higher traffic, right? If my road's intended to alleviate congestion, but more people are moving to the area, is it going to have the benefit that I'd say it's going to have? Those are indirect effects. You have to think about those too. And cumulative effects. So we're talking about past, present, and future reasonably foreseeable actions. Okay, regardless of who undertakes them. So again, my pipeline example. Right, I'm focused on a 30-mile pipeline, but what other projects are there, upstream, downstream from me? Right, is this an area where it's a part of a larger project for segmentation issue? Even if it's not, right? Well, what's my pipeline going to serve? Are there new power plants planned? There's some that are going to be retired, right? If it's next to a river, what other discharges to that river are there going to be? What's going to be the cumulative incremental impact of that? You have to consider all of that, and that really is where there's a lot of problems in applying it. So the important impact, again, is as we get into the three kinds of things you can do, the three ways that you can satisfy NEPA, you can do it in any of the three ways. You can always defer to, you can't always do it in three ways. You can always do an EIS. You can do an EIS for everything. You can always take the most conservative, your fear of litigation. I want to make sure my considerations are documented in the record. I'm going to take 3 years. You can do that. You're within your legal rights to do it. You can't sue an agency because it took too long to do NEPA. But it's that problem that default to more paper, that really is where the problems with NEPA implementation are coming into effect. So, why would I want to do it another way? Well, because it saves you a lot of time and money. Agencies are project proponents, and the public should be interested in their dollars being used efficiently. If we can do NEPA and get the same level environmental review in a shorter time or concise package, that's a standard that we should strive for. So, categorical exclusions, this is the most common way that you can, and the most common way is to basically say, this is class of actions, I've done it again and again and again, and it never has significant impacts. All right, so you can qualify, and these are codified in individual agency regulations, but it's not automatic. So you have to make sure that there's no unusual circumstances that would preclude us. So yes, if I'm building a side road, if I'm just taking any action that might be categorically excluded, but where I'm doing it, there's a special geographic feature, right? Or special species. You have to consider that. And you may need to do more NEPA in that particular instance. So, for example, like the United States Department of Transportation, for CEs, they have construction of bicycle and pedestrian lanes, landscaping and installation of traffic signals, buying new copiers, right? Federal agency action triggers NEPA. Well, I mean, how much do we really have to do for that? So those things should be categorically excluded. And you could do those typically in weeks or months. It's supposed to be streamlined. And that categorical exclusion is the final determination. You can challenge that in court if you disagree with it. And there's been a crackdown recently on the use of CEs. CEQ issued guidance in 2010 on the establishment of them. How do you put one into your regs? You should be reviewing them every 5 years to make sure they still apply, that they're not stale. And how are you using them? Are they really being used in situations where they were intended, or are they being used too broadly?
Yeah, wasn't it the case that Deepwater Horizon was a categorical
Yeah,
exclusion?
when exploration plans were categorically excluded offshore. And there's a whole hierarchy of approvals you need, but that step between having a lease and having an exploration plan was categorically excluded.
Yeah.
And that was that's been changed. They've rescinded that categorical exclusion. Some agencies even go a step farther. So BLM has something called a determination of NEPA adequacy, or a DNA, which basically allows them just to use a prior approval to clear NEPA for this one. It's an interesting concept, but hasn't really taken hold yet in a lot of different agencies.
They still issue a decision record as well.
Yes, they will issue a DNA decision, and that will be challengeable. Correct. Next step up, environmental assessment. So let's say no CE applies. I can't find one, but it's not clear that there's going to be significant effects either. All right, so we can prepare an EA. All right, there's no prescribed format for an EA at all, but you're supposed to consider things like the purpose and need for the proposed action. I'll talk about this a little bit because these are also in an EIS. Your feasible alternatives, your environmental effects, and who you consulted. It's supposed to be similar to an EIS, but just far less expansive. It's supposed to take less time. And at the end of your EA process, if you find no significant impact, you issue what's called a FONSI, or finding of no significant impact. That's your final decision. That's challengeable in court. Or if you find significant impacts, you roll over to an EIS. Do you have to start all over again? No, you can use the work you did, but in effect, you are going to be looking a lot closer at an EIS. So if you know you need to do an EIS, there's advantages to just starting on the EIS track rather than having to convert from the EA track to the EIS track. Another thing I want to mention is something called a mitigated FONSI. These are somewhat controversial, but they've been fully endorsed by federal agencies. And basically, if my action is going to have significant environmental impacts, but I know that I can mitigate it, I can build an 80 wind turbine project instead of 100. Right? I can move it 10 miles from the river instead of adjacent to it. I can take actions that are mitigate an otherwise significant impact and make it so it's insignificant, and then I can do an EA and a FONSI on it. The catch is you're bound by those mitigation features. You're committed to them. If you don't abide by them, then you're open to challenge. You may have to start all over again and do an EIS. It's supposed to save time and money in EA, but again, the downsides, it provides less formal procedures for public review. And it's scrutinized a bit more closely than EIS is in court. So the number one claim that's brought against EA actions, and again, they're far more common than EISs, but less common than CEs, is that we should have done an EIS because these impacts are significant. Okay, you open yourself up to that claim by doing an EA. If you do an EIS, you don't have that claim. You don't have that procedural claim. So that scares a lot of agencies. But sometimes they do an EA and they make it look, it walks and talks and quacks just like an EIS. And so, really, what are you doing here? And that's, we advise our clients on that issue all the time. But the CEQ prescribes 15 pages for an EA, and I've never seen one. Never seen one. I've seen it take hundreds of pages, 1 to 2 years to complete. Very little practical difference a lot of the time in practice. So last but not least, the environmental impact statement. There's a lot more. These are typically for programmatic decisions, a land use plan for an area where there's going to be individual approvals under it, large-scale regulations. They're going to dictate how a program is going to be administered. Mega projects, huge interstate highways, transmission lines, power plants. These are typically EIS actions. As an example, usually less than about 1,000 EISs are prepared each year, but there's 100,000 Clean Water Act 404 permit applications every year. Kind of gives you a sense of it. There's, why an EIS? Why do we care? There's more process, more described process. It's in the CEQ regs and it's in a lot of other agency regs. And you have to do a notice of intent. You have to do that to stick. You have to let people know that I'm starting a NEPA process, I'm starting an EIS. And then initiate scoping. And scoping is really important. Scoping may be the most critical part. It's where we decide, what are we building? What do we care about? What are we doing here? What are the issues? What do we care about? What don't we care about, right? If I'm building a road in the east, I don't really need to care about Western endangered species, right? That's what can I exclude? What can I narrow down so that we focus on the issues and don't just do more paperwork, where we actually get a better, more informed decision. That's a public process. There are comments submitted. There are public meetings, and then the agency takes this back and prepares its draft EIS. What does an EIS look like? Well, here's some basic anatomy, and there's no set form, but this is typically what it covers. And let's go into it just a little bit. The purpose and need statement. Went too far. Purpose and need statement. This is the foundation of the EIS. So never has so much legal thought gone into so few words. The statement really explains why the proposed project is needed and what it's supposed to accomplish. And it has to be reasonable in scope, okay? So it can't be artificially constrained so that you're going to exclude alternatives. So, for an example, I worked on a Maryland project for a client sponsor. It was a highway project. And we worked really hard on describing what our goals were for that project. It was to move freight, to alleviate congestion, to be consistent with local land use plans. These were all part of our purpose and need statement. But what if we had just said, my purpose and need is to build an 18-mile road in this corridor? Well, that's, you're pretty much prejudging the action. What's the point of doing the NEPA? Because you already decided what you're going to do, right? But on the other side, if I would have just said, well, my purpose and needs to reduce congestion. Well, that could be anything, right? It could be a transit project. It could be more walking. It could be a different way of zoning, so people are living closer to work. Anything could serve that purpose. So it really has to be practicable. On this one, we were challenged in our purpose and need, and we won. Purpose and need statements have been challenged a lot. You know how many times they've ever been overruled? One time, ever. The case is called Simmons, and it was in Illinois, and they were extremely. It was a very stark set of facts. But courts typically defer to agencies because what are courts to say what the agency should be doing?
And all agencies kind of do it their own way,
Right.
Like
Correct.
FERC, they sort of just whatever the applicant sends to them becomes the purpose and need. Whereas other agencies say, we want to kind of alleviate congestion in this area. So.
Correct. The heart is the alternatives analysis. So it's, of course, dictated by my purpose and need, right? We have to do a reasonable range of alternatives. They have to be practical. They have to be feasible, technically, economically, right? Can't be Yes, I mean, I want to build a landfill, but we also could launch it into space. Well, that's not really an alternative we're going to carry into detailed analysis because it's not technologically or economically feasible. You have to identify your preferred alternative and your environmentally preferable alternative, which is going to have the least environmental impact. But again, you don't need to pick the alternative that's going to have the least environmental impact. You just have to analyze them. And so, as an example, my client, another client was another highway project in Ohio. Truck traffic had dramatically increased. It was a small town, and the plan was to build a bypass around the town to minimize traffic and increase safety. Federal Highway considered a number of different alignments for the bypass, but the local citizens sued. And they argued that the alternatives should have been considered, such as tunneling the highway under the town to avoid any surface impacts. We can build it underground, right? But we argued that the tunnel proposal wasn't a reasonable alternative because it wasn't anywhere within the highway's budget, and we won that argument. You also want to identify alternatives that you've eliminated, reasonable alternatives that you've eliminated from study. So purpose and need, very important. Alternatives, they have to meet the purpose and need in order to be reasonable. All right, then we're looking at effects, right? We've already talked about direct, indirect, cumulative effects. Well, we look at what exists now, and we look at what's going to happen if we build alternative A, alternative B, and alternative C. We always have to have a no-action alternative. That's one thing you always can have. There's no minimum number of alternatives. You can have 2. That's enough. That's legally enough. But you have to have no action, and you have to have your proposed project. But you summarize what each alternative is going to do to the environment, and you also list out your mitigation measures. If you are going to, let's say you're in the EIS, I'm not worried about a mitigated FONSI, but there's a lot of public pressure on us to increase, we're going to take a certain amount of parkland, and we should increase it on a 3-to-1 ratio. Every acre we take, we should put 3 more in, right? That's a pretty significant commitment. If you're going to commit yourself to that, you should follow through on it. There's a problem of paper mitigation, so they agree to it, agency passes the action, and then it never happens, right? That's a problem. So there's a bit crackdown now on paper mitigation. This is where NEPA gets a little bit substantive, right? If you're going to commit to mitigation, you should put it in your final decision document. The review, draft environmental impact statement is you issue a draft. This is my environmental impact statement. Public, I want you to be aware of it. What do you think? You request comments. EPA gets a copy of it, and they rate these things. You have to be at least 45 days with bigger projects. Obviously, it's a longer period, and you have to address the comments. So the final EISs, all right, remember how important I said scoping was to really ensure we're considering the right effects. The other really important thing is how the agency responds to comments it gets on the DEIS. Right, so the agency isn't allowed to just say, don't agree with it, I don't like this person, I don't like the comment. They have to actually prepare a response, and those are very important if these projects get challenged, to have the administrative record reflect the agency considered and had a reasoned explanation for rejecting or not changing its project in response to the comment. There's a 30-day cooling off period. You're supposed to think about what the action you're going to take, and then you issue a final action, which is a record of decision. And that's a ROD. So for CEs, it's the CE determination is challengeable. For EAs, it's the FONSI that's challengeable. For EISs, it's the ROD. That's the point where it becomes ripe for challenge. All right, one last little thing, supplemental EISs. So we're done, right? It's taken me 5 years to get through and talk to everybody and get everybody on the same page and respond to comments and bat down the opposition and finally have a beautiful FEIS. Well, 5 years, maybe 10 years, it's taken a long time. Things might have changed on the ground. So do you have to start all over again? Sometimes. Sometimes you do. And you have to look at where there's substantial changes, significant new circumstances or information, right? So one of the big things after Deepwater Horizon were all the leases or the lease sales that were contemplated, and there were EISs done before they were conducted. Did they need to be redone because they didn't contemplate an oil spill of the magnitude of Deepwater Horizon? Okay, hotly litigated issue. So far, the holdings have been no, they didn't need to do it again. because they properly anticipated they didn't need to do a supplemental. But they have done supplementals for some of the actions out there, and so the mere passage of time doesn't mean that you have to do it again, but you always sort of have to have it's a moving target and be able to anticipate. In my project, the Maryland one I mentioned, there were new rules passed about particulate matter, right? A year into the project, and we already had scoped, we had done all the modeling. How do we encompass? You're talking about starting all over again, and that really was difficult to accommodate. But we did in the process itself before the issue was crystallized. So guess how many times the government has lost, on NEPA cases in the Supreme Court? Anybody say less than 100? Raise your hand. Less than 10? Less than 5? 0. Never. So a lot of lower court decisions that remand things back. The ones that have been appealed all the way up to Supreme Court, they have always upheld the agency. So, what does that mean? Well, it doesn't mean you get a free pass, but it means that documents are getting better, analyses are getting better. Your submission, it's all about the administrative record. So, again, before I hand it over to Adam, what is a court looking at when it reviews a NEPA case? There's no independent action under NEPA, no cause of action at all. So how can you sue? Well, you sue under the Administrative Procedure Act, and you say that the agency's decision, the decision document, as supported by the NEPA document, was arbitrary, capricious, abuse of discretion, not in conformance with law, and you get it that way. And courts are applying a very, very deferential standard of review. They look at the administrative record. They look at what was before the agency at the time it made its decision. If there's a reasonable basis in there, the court doesn't substitute its judgment for the agency. It defers to the expert agency. But it's very important, again, to have that record be as bulletproof as you can, and that's a lot of things that we work with our clients on, trying to have negative points brought out in the record. Don't hide them. Bring them out. Address them head on, right? So then you show you consider them. The worst thing you can do in NEPA is not consider something, even if it's bad, quote unquote bad. But it's a rule of reason, and if you've done that hard look, then your decision will be upheld. So you've heard me talk enough. I'll hand it off to my buddy Adam.
All right. Thanks, Jamie. So, I'll be talking about, let's see.
Birds, bees.
Here we go. We'll be talking about the Endangered Species Act. Basically, it's good to follow on Jamie's presentation since the ESA is a really good counterpoint to NEPA. Like NEPA, the ESA requires agencies to follow certain procedures. And, when you have a federal project, both processes tend to run in tandem. Unlike NEPA, on the other hand, the ESA actually requires certain outcomes. So, for one, federal agencies must ensure that their actions don't cause jeopardy to threatened or endangered species or modify its critical habitat, adverse modification. And secondly, there's a more broad prohibition that applies to any person within U.S. jurisdiction that you can't take a threatened or endangered species. And so for this reason, for the stringency of the act and its ability to halt federal projects in its tracks, it's been called the pit bull of environmental laws. So getting into the history, basically, as Jamie mentioned earlier, this was among the wave of environmental laws of the late 60s, early 70s. The ESA came about in 73. And it was preceded by a few less comprehensive versions in 66 and 69, as well as many other species preservation laws that were focused either on certain subsets of species or certain types of actions, which I'll be getting into a little bit later. In terms of the agencies responsible, the agencies that actually administer the ESA, you've got two. First, you've got the Fish and Wildlife Service under the Department of the Interior, and they handle land species and freshwater species. Then you've got also the National Marine Fisheries Service under the Department of Commerce, and they handle marine and anadromous species. And if you're asking what anadromous species are, those are basically fish that spend part of their life at sea and part of their life in freshwater, like salmon or sturgeon or striped bass.
It was the Obama comment is freshwater salmon and saltwater salmon. And
Oh, yeah.
regulated differently, but
Yeah.
anyway, that's how it's split.
Yeah. No, it's interesting. So basically, the basic getting into the basic concepts of the ESA, it's got one central premise, and that's to protect and recover imperiled species and the ecosystems upon which they depend. And to get there, you've basically got four main provisions. Under Section 4, that covers the listing of species in their habitat. Section 7 covers federal actions, so that requires consultation in order that federal agencies don't cause jeopardy to a species. Then you've got Section 9, which is kind of the broad prohibition on take of threatened and endangered species. And then Section 10, which is a set of procedures to avoid liability for Section 9 take. So kind of to get things started, I thought it'd be good to start with Tennessee Valley Authority v. Hill. If you've heard of one ESA case, it's probably this one. It was the first ESA case to reach the Supreme Court, and it's the case that reaffirmed the Act's authority. Kind of for, from the perspective of law school, it's sort of like the Marbury v. Madison of the ESA.
Right.
So, ironically, though, it had probably almost the worst possible facts of the first case that was premised on the ESA's actual authority. So, as you probably heard, it's centered on the Tellico Dam. You can see a little map up there. And it was a Tennessee Valley Authority project on the Little Tennessee River. Congress had authorized it every year since 1967 and had appropriated about over $100 million to it. Now, conservationists had opposed the dam from the beginning. They attempted litigation under NEPA to stop the project, which was ultimately unsuccessful. But what changed everything was that in 1973, biologists from the University of Tennessee discovered this 3-inch tan-colored species of perch that was previously unknown upstream of where the dam was going to be installed. And it came to be known as the snail darter. They estimated about 10 to 15,000 of them existed at the time, and only in that stretch of river, which would be completely inundated after the dam closed. So 4 months later, after this discovery, Congress enacted the ESA, and 2 years after that, the Fish and Wildlife Service listed the snail darter as endangered. So it quickly became clear that completing the dam and closing its gates would completely wipe out the snail darter. And it was also clear that the only way to avoid this would be to abandon this project, which Congress had authorized, had already expended $100 million for, and was, very, had a lot of money going behind it. So the question that reached the Supreme Court was, would completing the dam be in violation of the ESA? In other words, how far does the Act really go, and does it apply to projects already approved by Congress prior to the Act's existence? And the Supreme Court's answer was a resounding yes. So as you'll see, I apologize for putting blocks of text up there, but you don't have to read them all. But the court had some pretty strong words about how far the Act goes. Basically, it may seem curious that we've got this small fish that's going to hold up an entire dam that Congress has repeatedly authorized, but the explicit provisions of the Endangered Species Act require precisely that result, no exceptions. And the court hinged this outcome on a few points. For one of the Tennessee Valley Authority's main points was, well, we're already funded, we're already authorized. That it doesn't make sense that something that was decided before the Act came into existence could get stopped now. And the court pointed to the fact that a federal action is also defined as carrying out, a federal agency carrying out an action. So to close the gates of the dam, the TVA would have to carry out the action. Mm-hmm. Secondly, the court particularly raised that previous versions of the Act had phrases that sort of qualified the no jeopardy prohibition, like to the extent practicable, whereas the Act of 1973 didn't have this. So it's just across the board, no exceptions, this is how it had to go. And so, at an early stage for the Act, it was a real affirmation of its power and its purpose. In the aftermath, the dam was stopped, the darter was safe for the time being, but congressional action was swift. First, the first way Congress tried to approach this was to amend the ESA to include an exception, the Endangered Species Committee, which is also known as the God Squad. And that actually didn't work. And so when that failed, Congress passed a bill directly mandating the completion of the dam in spite of the Act's requirements. So that did the trick. The dam closed its gates in 1979 as expected, the snail darter was completely wiped out in the Little Tennessee River, but they managed to transplant it to a nearby river where it's been doing well since. And actually, sort of ironically, a year after the dam closed its gates and after this whole kind of throwdown over this, they've discovered a few other populations of the snail darter in surrounding streams. So,
Can you imagine that? I mean, today, I mean, you have an ESA result, and you need Congress to do something. I mean, what are you? I mean,
Yeah.
what are you gonna do? But that was the '70s, and there
That's
was
how
no
it-
internet, so.
yeah. So getting into the kind of the provisions of the act. First things first is Section 4. This is basically the prerequisite for every other provision of the act. You have to have a threatened or endangered species or critical habitat for those species. And Section 4 covers how the services list these species, designate their critical habitat, and set recovery plans for basically the species recovery to the point where they can get off the endangered or threatened lists. And you've got basically two ways you can list a species. One is endangered, and that's in danger of extinction throughout all or a significant portion of the species range. And threatened is basically likely to become endangered within the foreseeable future. After that, you've got critical habitat. It's meant to occur at the same time as listing, though with a qualification to the maximum extent prudent and determinable. So it doesn't always happen, at the same time the species is listed. And these are basically specific areas essential to the conservation of the species, whether within the area where the species currently exists or outside the area where the species exists at the time of listing. So it's an extra layer of protection. It basically is important for Section 7 consultation or Section 9 take liability. If you lose critical habitat, it's a pretty good indicator that you're harming the species in some way. Then we've got recovery plans. The service basically sets these as steps needed to restore the species to health. And these are largely internal documents for the service's use and for the most part have been unenforceable by outside parties, though there's been a little bit of back and forth on this in the courts. And finally, we've got Section 4D rules. And these are, if you list a species as threatened, the service can issue this rule that gives special requirements for the species. Basically, they relax the Act's other requirements. An example is when the service listed gray wolves in Minnesota. They, at the same time, issued a 4D rule saying federal agents will be permitted to trap and kill wolves that prey on local livestock. And technically, without the 4D rule, this would be This would be taking a threatened species. But in this case, they thought that having federal agents do this would be better than leaving it to locals who might take the law into their own hands, result in killing a lot more wolves. So they thought setting this rule would be prudent in that case. So basically, kind of the illustrative case or series of cases for Section 4 is Northern Spotted Owl v. Hodel. There are a few other cases after this, but this was in 1988. And like TVA v. Hill, this was one of the foundational conflicts that shaped the modern act. And it's also got some factual similarities. You've basically got a large-scale set of projects with a lot of money behind them up against a small species rarely seen by the public. Though, as you can see from the picture, it's slightly more lovable or, prettier than the snail darter. So by the late 80s, biologists had basically determined that northern spotted owls required old-growth forest habitat for their survival. And at the same time, the last remaining old-growth forest habitat within the Pacific Northwest was almost uniformly on public lands open to timber harvesting. So what precipitated all this was environmental groups filed petitions requesting that the service list the owl as threatened or endangered. And when the service gets a petition like this, it's got three ways it can respond. It can respond that the listing of the species is warranted, not warranted, or warranted but precluded by higher priority listings. In that case, they basically call the species a candidate, it goes back into the hopper, and they get back to it every so often. And in arriving at this determination, the service must look only at the biological risk faced by the species to the exclusion of all other factors. And in this case, the service sort of started out on that path. It engaged its scientists and said, look at all the scientific and technical data on the owl. And the scientists came back and said, yeah, if logging of old growth continues at this pace, the owl will go extinct in the near future. They put that up to peer review concurred. But the service came back and issued a not warranted finding. And this led the court to rule against the service. Although, the service is a scientific agency, and so it gets almost a special layer of deference over other agencies because, it has scientific expertise. But in this case, the service had ignored its own scientists and had really not offered an alternative explanation or scientific support for that finding.
Mm-hmm.
So, kind of the factual aftermath, the service went back, listed the northern spotted owl as threatened, gave it 12 million acres of critical habitat after subsequent litigation, and that sort of kicked off the next stage of the saga, which leads into Section 7 here. Here we go. All right, so Section 7 covers federal actions. It's how federal agencies deal with the Endangered Species Act. And at least from the perspective of environmental attorneys, it's the most visible provision of the Act. You see it attached to a lot of federal actions. It's sort of the bread and butter of the cases before courts. And specifically, when we're talking about Section 7, we're talking about Section 7A2. There are other provisions, but 7A2 is the main one. And above all, 7A2 requires that federal agencies ensure that their actions don't jeopardize the continued existence of endangered or threatened species or result in the destruction or adverse modification of critical habitat. And like we talked about in TVA v. Hill, federal actions anything authorized, funded, or carried out by a federal agency. So, to get there, to ensure that you don't jeopardize a species or cause adverse modification of habitat, the process is consultation, and it's a series of steps, and it's sort of like a flowchart, so that's how I've illustrated it here. So first, the action agency on its own determines whether the project may affect listed species or habitat. And if the action agency determines that the project will have no effect, that is, threatened and endangered species aren't in the area, or just the project will have absolutely no effect whatsoever on them, it gets to go forward. It can proceed. The process ends there.
But with no involvement with the Fish and Wildlife at all.
They don't even need concurrence. The service sometimes will offer them a letter of support, but it's not required.
Right.
So, on the other hand, if the action agency determines the project may affect listed species or habitat, the action agency's got to begin informal consultation. And so, under informal consultation, the action agency prepares what's called a biological assessment. And this determines whether or not the project is likely to adversely affect a listed species or habitat. So, before we had may affect, now we have likely to adversely affect. Now, if the biological assessment determines that actions not likely to adversely affect the species, the agency runs this by the service. Mm-hmm. It asks for the service's concurrence. And if the service concurs, the project's good to go. But if either the service doesn't concur, or if the biological assessment on its own determines that the project is likely to adversely affect the species, then formal consultation must begin. So, under formal consultation, the relevant service, either the Fish and Wildlife Service or the National Marine Fisheries Service, prepares a biological opinion. You may have heard this called a BIOP or a BO. And the purpose of the biological opinion is to determine whether the project will cause jeopardy of a species or result in adverse modification of critical habitat. And to do this, the service considers the status of the species, the baseline, the effects of the action. This includes direct, indirect, interrelated, and also the cumulative effect of other non-federal actions. So, it sounds a lot like NEPA probably here. So,
but it's extending to an action where NEPA might not otherwise be required. So I mean, you have a private project, right? I mean, I want to build a pipeline. I want to clear my land, right? It's private, but it doesn't matter for NEPA. No trigger, but ESA, maybe. Still.
Yeah, and I mean, it's interesting, like how it kind of approaches other federal actions. So under NEPA, you could look at cumulative effects, and that incorporates all sorts of things. But here, cumulative effects only apply to non-federal actions. Mm-hmm. Federal actions are supposed to get their own consultation. So basically, they say, if you've got another federal action going on, that's on you. You've got to figure that out. So, if the service determines the action won't cause jeopardy, it issues an incidental take statement. And that basically, as I've said kind of earlier, take is prohibited under Section 9 normally. But under an incidental take statement, the service allows take that isn't the purpose of the action, but is incidental to it. Excuse me. And two things that the incidental take statement includes are limits on the amount of take of species or habitat, and reasonable and prudent measures to minimize that take. And compliance with the incidental take statement completely insulates the action agency from Section 9 take liability. On the other hand, if the service determines jeopardy or adverse modification will occur, it issues reasonable and prudent alternatives to prevent the jeopardy. And so once an action agency gets a jeopardy biological opinion, it's got options. It can take one of these reasonable and prudent alternatives to avoid jeopardy. It can go back and just modify the whole project and reinitiate consultation. It can abandon the project, which is probably what the Tellico Dam required in that case. It can disagree with the biological opinion and proceed at its own peril, risking Section 9 liability. Or most rarely, it can apply to the Endangered Species Committee for an exemption. So here we are with the Endangered Species Committee, aka the God Squad.
They show up for work every day and just
Yeah.
sit there.
Yes.
No, I'm
No, for
just
some
kidding.
reason, I think of the War Room from Dr. Strangelove. So basically, the God Squad came about through amendments to the Act in 1978 after DVA v. Hill. And it's a committee of 7 cabinet-level members that vote whether to allow a one-time exception to the ESA for a specific project that will cause jeopardy. In other words, they're sanctioning the species demise, hence the nickname. So since its inception, though, it's only been convened 3 times. Once was in the snail darter Tellico Dam case, did not grant an exception there. Another time was in the northern spotted owl case. It did grant an exception there, though it was later challenged and settled. And then there's another dam later on where it was granted, but then another administration came in and withdrew the application. So the third of the major provisions is Section 9, and that's the take prohibition. And it's the key piece of the ESA. It's basically everything else branches off from that prohibition on taking a threatened or endangered species. It's the teeth of the Act. And it prohibits the take of endangered or threatened non-plant species by any person. So unlike Section 7, which just applies to federal actions, Section 9 applies to any person subject to the jurisdiction of the U.S. It's got civil and criminal penalties, and take is expansively defined. As you can see there, it's to harass, harm, pursue, hunt, etc., or to attempt to engage in any of those activities. And additionally, the service, since the enactment of the Act, went back and defined harm to include habitat modification where it actually kills or injures wildlife. And that brings us to another time the ESA has been before the Supreme Court. So this is Babbitt v. Sweet Home chapter of Communities for a Great Oregon. And basically, the Supreme Court looked at whether the service's expansion of harm to include habitat modification was a reasonable interpretation of the Act. And the parties challenging this definition were a group of landowners, timber companies, and families dependent on the timber industry in the Pacific Northwest and the Southeast. And the species at issue, as you can see, were the red cockaded woodpecker in the Southeast, and once again, the northern spotted owl in the Pacific Northwest. And the party's contention here was that harm should only be taken to apply to direct applications of force, not sort of broad or more vague types of harm like habitat modification. But the court rejected this argument and found that the service's definition was reasonable under the terms of the Act. For one, the court said, Congress's intent was really broad. It meant to get at specifically the activities that are endangering species. So limiting harm just to direct applications of force would cut out the Act's legs. Excuse me. Now, second, as we'll see in a second, the court looked at the fact that Congress again underlined this intent in 1982 when it authorized incidental take permits to private individuals. And so the court basically said, if there's no such thing as incidental take, then these permits wouldn't make sense. All right, so Section 10, that's how to avoid take liability. And this, this section was introduced in the 1982 amendments to the Act. And it's basically a mechanism for softening the impact of the take prohibition. And it's got 2 pieces here. You've got incidental take permits and habitat conservation plans. Now, an incidental take permit works a lot like the incidental take statement that we discussed under Section 7, in that basically as long as the take is incidental to an otherwise lawful activity and not the purpose, it can be permitted under an incidental take permit. Now, to get an incidental take permit, the applicant has to have a habitat conservation plan. And the required contents of the plan basically describe the take, how the applicant will try to lessen it, the funding it has for this, and basically other alternatives it considered but rejected.
So everybody sort of gets, I mean, Section 10 was added because private parties, all right, they had a really hard time. It's like almost an absolutist take prohibition, and they needed more flexibility in the act. And so the amendments adding Section 10 did exactly that. It's for private parties, not for the government. It's for private parties. You have a purely private project. There's no federal nexus, right? My land, I'm doing things on my private land. I don't cross a water body. So this allows me to go out and get authorization so I can proceed with confidence. If I conduct the activity and I take what I say I'm going to take and I protect the species survival through a habitat, I'm in compliance, I'm set. Section 7 is for the government. It's like it's issuing a permit to itself. The government can't do it. And the government actually views its granting of a Section 10 permit as something that triggers internal Section 7 consultation.
Huh.
So it's weird kind of thinking, but that is their position. And so whenever they issue a Section 10 permit, they actually do internal consultation for a Section 7 because the federal action is granting the permit. And is that going to jeopardize the species? So 7 government, 10 private, overly simplistic, but that's kind of thing.
And at the base of all of them,
take.
yeah,
Right.
you've got take really that's driving both.
Right.
So I mentioned earlier that we've got a bunch of other species preservation acts that came about before the ESA and still exist today and continue to operate. So I'm going to kind of run through a few of those. First, we've got the Migratory Bird Treaty Act. This was enacted in 1918, amended multiple times over the years, and it implements a series of treaties between the U.S. and kind of the surrounding nations like like Canada, Mexico, and some of the Japan and Russia for our Pacific territories for the protection of migratory birds. And it covers over 800 species of birds in the U.S., and it makes it illegal to pursue, hunt, take, etc. the birds alive or dead, their nests, or their eggs, unless you have a valid federal permit.
And they're not listed. I mean, these are not listed
Yeah.
species under the ESA. It's a migratory bird, so much broader coverage than ESA.
Yeah, so it's like essentially like a standalone take prohibition for migratory bird species with the option of getting a permit to allow it.
Right. And I have one other point, but I'll let you do the next,
Oh, sure,
the
yeah.
next one because they kind of go together.
Yeah. So, yeah, here's the Bald and Golden Eagle Protection Act. It came about in 1940. And like the MBTA, it's essentially a standalone take prohibition for eagles. It's got high fines, up to $100,000 for individuals, $200,000 for organizations. And it's actually become somewhat important lately because the bald eagle was delisted, removed from the list of endangered and threatened species back in 2007. So this is one of its remaining protections.
It's the MBTA. It's just everything old is new again, right? So the MBTA is a criminal statute. It's a strict liability criminal statute. You take, you're criminally liable. And the way, if there's a split in the way the courts have interpreted it, but if you build a building and the bird flies into your window, arguably that's an MBTA violation. Okay, that's as broad as it's been construed. You know, where this is really becoming front and center in the news. Anybody seen? It's for wind projects. Mostly onshore, and now they're starting to go offshore wind too. So birds, hundreds of thousands of birds. It's mind blowing, but they fly. They're attracted to the turbine. Sometimes they can't see it. The prey is not. It's on the ground, and they fly into it. So there's a lot of ways that they can be hurt. But that MBTA is a major problem for wind developers, and so is the Eagle Protection Act. The thing is, the MBTA actually does not have an incidental take provision. There is no incidental take exclusion under MBTA. Now, how do you get around that? Fish and Wildlife has come out with guidance, land-based guidelines for building these things. That basically, if you do what the Fish and Wildlife Service tells you to do, then they won't prosecute you. It's prosecutorial discretion. That's what they say.
Yeah,
So we know it's illegal, but we're not coming after you if you do what we say. That's your.
Yeah, they've got like for the Eagle Protection Act, they've got a whole checklist on the Fish and Wildlife Service's webpage. It's like, how do I determine whether my project affects an eagle? And
Yeah,
it's-
well, eagles are different. So eagle, there
Yeah.
is an incidental take,
Yeah.
as you pointed
Yeah.
out, and they just issued a rule that expanded it from 5 years incidental take. You get up to 30 years, and because the wind projects are going to be hopefully around for more than 5 years. But again, nobody has one yet. Nobody has one of these permits yet, and so it's and there's actually a challenge going on right now. The environmental groups suing on the 30-year rule, stating that it was properly promulgated. It was arbitrary and capricious to give a 30-year permit. So these issues are live. It's more than just your ESA coverage. When you get a habitat conservation plan, as a practical matter, now you have to cover migratory birds in it, and you
Yeah.
have to cover eagles in it, and it's broader than the listed species. So.
Yeah, they're old acts, but they're still very relevant today.
Very relevant.
So we've also got the Marine Mammal Protection Act. This came out right before the ESA in '72. And, like the ESA, it divides authority between the services. Fish and Wildlife Service handles more of sort of the more land-based freshwater species, walruses, manatees, otters, and polar bears. And the National Marine Fisheries Service handles more of the seagoing species, whales, dolphins, seals, etc. The main hook here is it prohibits the take of marine mammals in U.S. waters. Though it's got a sort of less expansive definition of take than the ESA. And again, like the MBTA and the Eagle Protection Act, it allows take permits for certain activities, or I guess like the Eagle Protection Act,
right?
yeah.
Right.
But such as incidental take from commercial fishing, and also special permits for aquariums and scientific research. So finally, we've got kind of our trade, our acts that regulate trade in endangered, not even just endangered, but certain types of plants and wildlife. So first, we've got the Lacey Act. This is actually, I read somewhere, it's the oldest of our wildlife preservation statutes.
That's probably right.
Yeah, it was enacted in 1900. It prohibits illegal trade in animals and plants, basically whether it's illegal under state law, federal law, or international law. So it's sort of, it takes on whatever, kind of is around. And it also regulates the introduction of non-native and invasive species to the U.S. And sort of the international half of that is CITES, which came about the same year as the ESA. It's basically a series of treaties, that the U.S. and now 180 nations total are party to. And it works as kind of the international components of the ESA and the Lacey Act, with the goal to ensure that global trade in plants and animals don't threaten their survival in the wild in their home countries.
So you guys have seen this in the news. I mean, the Gibson guitar fiasco under the Lacey Act, that the wood they were using was triggered under the Lacey Act, and CITES. I mean, they blew up all that ivory. So but that's all what CITES is about. It's a big priority of the Obama administration. International species.
Yeah. So, kind of after running through, a few, all the provisions of the ESA, I thought it might be worthwhile to kind of show it in action in a few cases that I've worked previously. So, first I've got Wild Earth Guardians v. Salazar, and basically this was a proposal by the Bureau of Land Management to lease 2 large tracts of coal for surface mining in the Powder River Basin in Wyoming. The mining itself certainly would have local impacts on the land, air, and water. We addressed those. But also we wanted to get at the fact that the Bureau of Land Management hadn't taken into account the impacts that the leases would have on climate change. These are big leases. These are 430 million tons of mineable coal, and burning it in coal-fired power plants. BLM basically put this forward, said it would result in 1.2% of the U.S.'s entire carbon emissions per year. So it's not just like painting the ranger station that results in VOCs or some sort of emissions. This is 1 out of every 100 CO2 molecules coming off the U.S. that year, or from man-made projects, is because of coal from this project. So we thought it was kind of a good way to try to raise this issue. And basically, the BLM started informal consultation. It looked at the species in the area, which were the black-footed ferret and a species of orchid. It didn't look broader than that because it didn't want to consider climate impacts. So it reached a not likely to adversely affect determination. And basically, its reasoning was that if we don't provide this coal, the coal-fired power plants are going to get it from someone else. So why should we have to look at this? So ultimately, we didn't even get to that question. The court ruled against us on a jurisdictional issue, so it didn't really get to the merits of the ESA issue with respect to climate change. But it's a developing issue. You're seeing this in more cases. Groups are trying this, and it will be interesting to see how this goes.
You guys had a NEPA claim too? In
We
that
did, yeah.
action? Right, and then what's what we were talking about before. What's the action, right? Is the action just mining the coal, or is it also the burning of the coal?
Yeah.
How foreseeable is that? And that's
Yeah, it was interesting because they basically said, why should we be responsible for something that we're not doing?
Right.
This coal is definitely going to get sold to certain power plants.
Right.
And it was interesting because apparently certain power plants they're all specially calibrated to burn certain types of coal. So if you're burning Powder River Basin coal, you're not going to turn around and buy coal from another place or another country.
It's low sulfur, right?
Right.
Low sulfur
Yeah.
coal.
So it takes a certain thing. So they can't exactly go anywhere else.
Right.
But it was an interesting case.
Yeah. Well, one again, that's an issue. One counter argument to that is the NEPA analysis that will be done on the subsequent action would capture that. But if you're talking about
Right.
private combustion, then you're really talking about air permitting, which is
Mhm.
not subject to NEPA. So is it captured somewhere else is often a consideration looking at what's the action. But anyway, go ahead. Sorry to interrupt.
No, that's definitely a valid point. So kind of the second one I've got here is the Center for Biological Diversity v. BLM. This dealt with a natural gas pipeline, Ruby Pipeline. It ran from Wyoming to Oregon. It was over 700 miles long, and it was complicated in part because of all the federal agencies involved. Sort of how Jamie was talking about earlier with all the cooperating agencies and everything, we had a whole host of them. You had the Federal Energy Regulatory Commission responsible for the overall project. You had BLM responsible for granting the right-of-way across federal lands. You had Fish and Wildlife Service there as the consulting agency, the consulting service, and also for the project's impacts on a national wildlife refuge along the route.
Mm-hmm.
Then you had the Forest Service there for a national forest along the route, and Army Corps of Engineers covered, there are over 200 water body crossings, so those all had to be permitted. And so we raised issues under NEPA, the ESA, and the Clean Water Act. I covered primarily the NEPA issues. My co-counsel covered the ESA issues, and those actually turned out to be the ones that really carried the day here. And the main ESA issue was, the pipeline affected a number of threatened and endangered fish species, primarily a species of cutthroat trout in Nevada and a variety of sucker fish in Nevada and Oregon, including the Warner sucker that you see on the screen there. And so, as you can kind of see in the picture, the route took this little dogleg up into Oregon. It avoided California, and that was in part due to the fact that California's got CEQA, and the gas was bound for California. The pipeline didn't want to have to get involved with CEQA because it would have added apparently another year or two to the project. So they basically ended in Oregon, and then they decided to build a separate project that would take the gas down to California. It's issues of segmentation there, but
Mm-hmm.
it didn't really play out that way. So in taking that dogleg, though, that's where a lot of the fish were. I mean, right in that corner of Nevada and Oregon. So they had to blast through a number of streams. They had to bore under them. They had to use a lot of water for hydrostatic testing in arid areas, which would also affect streams. And when it came to consultation, FERC and BLM properly began formal consultation with the service. And the service reached a no jeopardy determination. But the problem was, to get there, the service relied on basically this private agreement that the action agencies had designed with the project applicant that had conservation measures for the fish. And, the Fish and Wildlife Service tried to get this wrapped into the action because, if it's part of the action, it can consult on it. If it's outside the action, it can't really deal with it. So the action agencies refused. The Fish and Wildlife Service tried to consider it as a non-federal cumulative effect to reach the jeopardy determination, and the court found this to be improper. Basically, the court said, if you want to avoid jeopardy, you've got to have enforceable measures written into the project. They have to be part of the federal action considered by the biological opinion. Otherwise, a few years down the road, if the responsible party, if the private party here, the pipeline company, decides to stop abiding by the measures, there won't be recourse under the ESA. For example, if you've got like a more traditional project where all these actions are within the project and therefore considered under the biological opinion, if the applicant changes the action and causes jeopardy, the Fish and Wildlife Service can come back and say, okay, you've got to reinitiate consultation.
Right.
And if the action agency refuses, the biological opinion becomes invalid, thereby exposing the agency and the applicant to Section 9 liability. Additionally, to back this up, there's a citizen suit provision under the ESA, so private parties could bring suit to enforce against violations of the Act. So what we have here is, it was a private agreement, it didn't really have those hooks, and so the court invalidated the biological opinion and required the agencies to restart consultation. So in the aftermath, the pipeline's up and running, it was constructed, but having these enforceable measures in place and written into the project will be important because the mitigation for these fish will take years, and it'll be important to have both the service and private parties there to try to enforce these. So that's it for me.
So we have, you guys may have picked up on the way in, a fact pattern
Yeah.
that ELI, I understand, is using throughout this summer school series. And so we were going to, it's sort of in lieu of a recap, we'd like to use, I think we're ahead of schedule, I'd like to use the rest of our time is just to hit this fact pattern. It's just another example. You've heard several from Adam and me. Touch on this, and then kind of open up for questions. And I think we have a couple hot topics, to be thinking about as you're understand what these are and understand where the key issues are being played out, things to look for going forward. So, yeah.
Could you just mention that it's on the website also?
Yes, this is also on the website. It's called Fact Pattern Elk River Chemical Spill, and it's for the entire summer school series 2014. And it's a one-pager, and it's loose, well, not so loosely, predicated on the disaster in West Virginia that ended up fouling a good stretch of river from a coal facility, and it's a lot of this fact pattern would deal with enforcement, very clear Clean Water Act, and other elements that'll be hit in other sessions. But let's just talk about sort of the NEPA and ESA hooks. For those, you want to summarize what happened here and where the ESA?
Yeah, so basically we've got this spill. It's a large site. It was this came about 20 years prior, and it's got a lot more in the way of the Clean Water Act and the federal hazardous waste statutes. But where the ESA comes in is it says here clearly that we've got the diamond darter, which was listed by the service as endangered in 2013. So well after this project started. But as we've seen from TVA v. Hill, that doesn't matter. If you've got endangered species that your project will affect, it matters. Both under Section 9 and if you're a federal agency under Section 7. So if this company wants to take the diamond darter, or even if it just
Or
does
if it
take,
has taken
it has taken
doesn't
the
really
diamond
want
darter.
to, but
Yeah, it would have to obtain a permit under Section 10 to do so. Otherwise, it's liable under Section 9. And the chemical spill, as looking at whether that's take, it seems pretty clearly to be take, provided you can show that it actually harmed the fish. And we've got sort of facts here saying that the local environmental protection agency for the state didn't observe any dead fish. So any potential plaintiffs or the service, for that matter, if they wanted to try to prove take, they would have to show their own proof that harm occurred in some way.
Yeah, that's a very important part of the ESA to understand that the Fish and Wildlife Service is not a permitting agency like like BLM would be, or the transportation would be, or the Corps would be, the Army Corps of Engineers would be for a Clean Water Act permit, where you can't proceed until you have it. It's just not prudent to proceed until you have your incidental take coverage under Fish and Wildlife. So you can continue. Fish and Wildlife cannot stop you from going through and doing it. You can disagree, like Adam said, with their determination, but you take, and they can prove take, you're liable. And that's significant. It could have significant, and if you did it knowingly or willingly, there could be criminal penalties there. So that's, here they're probably looking at fines as opposed to permitting.
Yeah, definitely. And I would say if you want to try to break down a fact pattern similar to this, first things first, just look for species or habitat there. Second, look if you've got some sort of take, and then third, look to see if a federal agency is involved. And
Right.
so kind of 3 points that would be relevant to a case pattern like this.
I completely agree. And the NEPA angle is a little different here. I mean, if we had done NEPA in advance, maybe this wouldn't have happened. So it sort of shines on what the value is of looking before you leap. There really isn't a NEPA trigger here that is stated in the fact pattern. And again, there's no federal agency action, no federal hook. It looked as a private facility. For coal production, I don't know if it was federal lands that may have required a BLM permit. Was like, did the NEPA conceive of the potential impacts of a spill? But it should have in that scenario. But looking forward, NEPA might be implicated on these lands if what you're going to do with them, right? So. Like I said, if this is a cleanup site under RCRA or if it becomes a Superfund site, under CERCLA, that would not be subject to NEPA because those are separate EPA authorities that basically are found to be equivalent. There's actually statutory and judicial exclusions for them. But if there were going to be improvements on the site, if they were, you were going to build again, or you were going to build nearby, or next door, build another one of these facilities, upstream. Your cumulative impacts analysis should include what the state of the river is now, what other projects could contribute. So not just it's not a worst case. You don't need to do a worst case scenario, but you need to be cognizant of, again, context and intensity. Where are we doing this? And it's now a different environment than it was before the spill. So you have to accommodate that if you have a NEPA trigger. So sort of before we kind of go to hot topics, so it's sort of a good time to open it up and ask if there's questions on NEPA, on ESA, on how they go together, and
on the fact pattern,
or wherever. Yeah, in the front.
Sure, I've got one. Regarding take of, in this case, I guess this diamond darter. For something small like that, how do you prove take? What's the requirement there?
So the question.
Oh yeah. So the question was, since the diamond darter is presumably a small species, how would you go about proving take to show that the species actually that Section 9 take occurred? And yeah, that's a good question. It's I don't know. I haven't specifically recently looked at the regulations as to how proof of take goes, but it's broad. So basically, under this case, you would say, well, presumably a spill of chemicals that poisons the river in some way would be a habitat modification, given that that this is our adverse modification of habitat for the species. It didn't say whether this is critical habitat here. I don't think.
No, I don't think so.
But so that's difficult. But there's kind of this mantra that you need to be able to show like dead or harmed animals, and if you can't, it's just a really sort of harder issue. So I'm not sure if you got any thoughts.
Yeah, well, I mean, we might cover this in the hot topics last part, but if it is critical habitat, it's easier.
Yeah.
Because they're, again, one of the things it's in flux right now is what is critical habitat? How do we define it? So that would be a bit easier to show because the types of actions that are destroy or adversely affect critical habitat is being proposed to be expanded. But for take of the species, showing a change in chemical composition of the water usually it's just not enough. You have to show some. It would be an enforcement action, administratively probably, depending on what agency was coming after you. Probably be a preponderance of the evidence type of standard. They're coming after you criminally. It would be a different standard for that. If you were going to challenge. If the justice was going to come after you in court, you'd fit that in court. If you were going to challenge an agency decision based on that, would be an arbitrary or capricious determination. So you need some evidence, but it sort of guesswork isn't enough.
Yeah, I think there were. I can't recall the site off the top of my head, but there were a series of cases about this where basically it was clear that animals had died, but they didn't have a body. So it was just I can't remember his name. Was that the Palila cases, or I'm not sure. But anyhow, it's hard. You have to show the actual harm or killing of the animal occurred.
Yeah, question in the front.
Yeah, what options do individuals or environmental organizations have if a government agency prepares an environmental assessment instead of an environmental impact statement? What do you think the more rigorous position?
Right. So the question was, how does the public get involved in an environmental assessment process, particularly if they think that environmental assessment is inappropriate for the action? This is part of the 40th anniversary reforms. The CEQ's position is, and some agencies take this view. Some agencies in their regulations treat EAs like EISs, and they put in, remember, all the process requirements, the notice of intent, scoping. Scoping is not legally required right now for EAs, but under some agency regulations it is. And CEQ's position encourages agencies to do similar scoping for EA action. So public knows there's something proposed and happening before it's too late, and so they can actually provide comments before the decision's being made. But there are less formal opportunities. How you participate, if you get wind of whether they in the Federal Register, if it's on agency websites, they're using that more often. If you're in a particular industry, you're probably tracking different kinds of approvals. The Freedom of Information Act under FOIA is a very popular way to get information on things. But you essentially can submit comments at any time. You can submit comments on the letter. You can comment on a. Sometimes there's a draft EA, just like there's a draft EIS. You can comment on the final, and if there's a FONSI that you disagree with, then you have the option to sue on it. Typically, it will be where the action occurred, but DC is also a typical venue for that, and your claim would be significant impacts. The finding of no significant impacts was arbitrary and capricious based on the record didn't support it. It's a tough claim to win, but it's more frequently successful than arguing an EIS wasn't rigorous enough.
Yeah, I'd agree with that. Just if you want to have a claim later on, definitely get in with comments. Because that will kind of define the scope of the argument you can bring later. So
yeah, and how do you find out about it? I mean, you establish relationships with your your local field office. You get to pay attention to the newspapers, what's going on. Nothing happens that quickly anymore, but some do get under the I'd say defense is kind of one where it's not always public. It's the national security. They don't always publish what they're doing or propose to do, but there's definitely ways to get involved.
And EPA puts EISs up on it.
They do. EPA again. EPA's role is weird. They grade the EISs, but they manage it, and EPA is actually the one that finally publishes it. So that was an amendment they made to NEPA. It's really the only substantive amendment they made shortly after NEPA was passed. But yeah, you can find EISs for any project, typically on the lead agency site or on EPA site. I think they have a library there. Yep. Anything else on the phone? You guys still there? Yeah.
How do the NEPA analyses account for uncertainty in the environmental impacts? Do they just assume worst case scenario, or how can I look at that?
So the question is, how does uncertainty get accounted for in the NEPA analysis? And it's a great question. The black and white answer is no. It doesn't require a worst case analysis. It's a frequent claim that it should, but it doesn't require a worst case analysis. But there's a regulation under the CEQ regs that requires you, if there's unknown information, you have to basically take reasonable and cost-effective steps to fill in gaps. You can't just throw up your hands and say, this is too hard. You have to basically document what you know, why you don't know more, and what would be required to learn more. So if you would have to do a multi-year study on the effects of a new road project on local air quality, that probably would be required. You probably would have done that as a prudent agency, but just hypothetically, if it's the cost of that would be huge relative to the cost of the whole project. You don't sink the project based on having to do effects of it. It has to be within the rule of reason. But there's always uncertainty. I mean, it's predictive. I mean, by its nature, it's predictive. The other way to get at it is through the mitigation. Remember I said they're really cracking down and trying to make mitigation binding, putting mitigation in the ROD that you commit to particularly if you're doing a mitigated FONSI. And so adaptive management principles are more and more featured in there. And if it turns out the mitigation that you proposed is not working, then you need to come back to the table and find how to do something else. So we can mitigate some of that uncertainty through how we implement the project.
Mm-hmm.
Hope that answers it somehow. It's an uncertain answer to the uncertainty. Well, why don't we, maybe this will trigger some questions. I think we just have a couple more points we wanted to make about what's sort of coming down the pike.
Yeah.
So I'll go back in time. I love the God Squad slide.
Sure.
Uh,
Sure.
So some modern NEPA hurdles. I mean, you hear it all the time about, why are we doing so much study? You see a lot of legislation that's out to repeal, amend NEPA, get things on a fast track. And the problem is there's a lot of frustration about doing these documents that for, the state, there's, just a report on the state of the nation's infrastructure, and, most of its roads are, rated C or lower. They're failing. You have bridges crumbling, literally. And, should we really be delaying fixing these things while we look at, multi-year environmental impacts? Why do these delays happen? I mean, the agency's not playing well together, sneaking up, sandbagging at the end, right? Being strategic amongst each other. Again, turf wars between the two of them. Federal and state, right? So, I mean, we also have state laws that you need, and sometimes the state process won't start until the federal process is over. Well, that's just time wasted. Duplication of effort, right? So you have NEPA, but you also have all the other environmental statutes you need to comply with. If you need a Clean Water Act permit, you have to do an analysis under that. If you're going to affect a historic property, you need to do Section 106 consultation and analysis under that. If you're taking parkland, you need to do analysis under Section 4F. So how can we get these documents into one place? How can we do them, all at the same time? And project components. I mean, NEPA has it triggers very strong views on one side or the other. I think everybody agrees it's a good thing, and it's been good overall. But it is a litigation tool, and if you have a road or a mine or whatever development project is in your area and you don't like it, you can bring suit under NEPA. You might not always get an injunction, but it's not that hard, because again, your argument is if the thing's built, well, and I win, it's a Pyrrhic victory. So it's not that hard to get that. And a lot of times project opponents will wait until the last day under the statute of limitations to sue. So thousands of pages of analysis, do we really have a better project? Arguably no. So, there are some positive signs of progress, and a lot of these are featured in several proposals, but new categorical exclusions, taking a fresh look at them, what are they really working for us? Are there other ones we can have? Planning a NEPA. So I'm doing land use planning for NEPA. I'm a metropolitan organization, and I'm planning my suite of projects, but in doing that and determining where I want what project, where do I want transit, where do I want rail, where do I want roads, where do I want bike lanes, having that tiered into having NEPA combined with that, so that once you get to your menu of options, you've done some of that thinking. That really helps. Concurrent reviews, getting agencies in the same room, doing it all at the same time, right? At the outset of a project during scoping, if you're Fish and Wildlife, you perceive a problem, come to the lead agency, talk to them about it. Might not agree with you, but bring it up early, so maybe we can tailor the project before it starts getting a lot of momentum. Deadlines, right? There's no time. Again, you can always do more NEPA, but there's right now no legal time that you need to be finished. So the idea of having deadlines in the latest transportation reauthorization that happened in 2012 is called MAP 21, and it put in a requirement that agencies should be setting deadlines when they at the outset of a project. There's even penalties that DOT can now assess against other resource agencies for delaying their actions more than 180 days after the DOT's analysis is done. That's rare, but it's in the legislation, and now it's just recently enacted in rules. Putting the FEIS and ROD together, the 30-day cooling period. I mean, assumption that your final is going to be final. States, getting them involved and getting joint state and federal EISs to be the norm. And accountability. I really think this is a big one. We don't know. There's a lot of charges. There's a lot of rhetoric on both ends about NEPA, but we really don't know because we haven't been measuring comprehensively what NEPA is taking us. And so there's a new report out by GAO. I think it's GAO, CBO. Can't remember which one. But it's the first, and now every year under multiple statutes, including the proposed reauthorization for transportation, you're supposed to put you're supposed to account for how many EAs you did, how many EISs you did, how many categorical exclusions you did, what each one averaged, the time and money. They put up a dashboard on the Department of Transportation's website that has status of each project. Where is it in the process? How long has this part been going on? Are we on schedule? So it really gives visibility to where it is, and it's not done in a black box. So, there's been a slew. Some of them have been legislative, some of them have been presidential. Just a quote from Congress in MAP 21, that was the July 2012 Transportation Reauthorization Bill for 2 years. Congress declares it is in the national interest to expedite the delivery of surface transportation projects by substantially reducing the average length of the environmental review process. I mean, for Congress to say that, it's a pretty big deal. The president has put out a memorandum in 2013 and just last month an implementation plan for it for modernizing federal infrastructure review and permitting regulations. And the goal is to advance the goal of cutting aggregate timelines for major infrastructure projects in half while also improving outcomes for communities and the environment. Again, half. I mean, that's big. So, and one other thing is sort of making your NEPA analysis go farther. So there's a new focus on programmatic. So if I'm going to be doing 10 similar projects in the area, can I analyze them at the same time and use that baseline analysis without redoing it each time? Mitigation, programmatic mitigation. So for species, right? I mean, some of the big ones out there are sage grouse, lesser prairie chicken. These are diffuse species throughout huge geographic range that rely on sagebrush, basically, and they're a huge impediment, if listed, a huge impediment towards development. Well, what if we could have a programmatic approach? If instead of having 10 acres dedicated here in an HCP, or having fragmented habitat, which is really leading to their decimation, and we have dedicated area set aside, or mitigation banks, private mitigation banks, where you could pay in, and you could get credits towards species conservation. So these are all ideas about how can we actually make the mitigation work more cost effectively with more certainty, and there's ways to get that done. So I'll just say for NEPA, remember it's a stop and think statute. Build your record. Good things, bad things, don't hide anything. The NEPA analysis is project specific, but use what you can. And try to, like I said, acknowledge information gaps, and keep following these efforts. I mean, they're in Congress right now. They're being put out by the administration because Congress isn't doing anything. Really important stuff that should make the very large bureaucracy work better, while also protecting the environment. So, if you guys have any ideas, and love the fresh ideas. So based on that, we have a little bit of time. Any other questions about how this works, or something you might be working on, or on the phone?
Got a few hot topics for ESA.
Yeah, sorry.
Yeah.
ESA hot. There are no such things.
Yeah, no, I'll just do them quickly. But yeah,
Sorry about that.
it's been a while. So basically kind of the three things that I've got here are, for one, these sort of key terms for the ESA, they're still in flux. Like we saw in Babbitt v. Sweet Home, the Endangered Species Act is a statute that relies on the specificity of its definitions. If harm isn't adverse modification, I mean, the statute's completely different. But so the Fish and Wildlife Services put forward a few proposals. One is to redefine adverse modification of critical habitat, and that basically actually expands it in a way. Previously, I think the last set of regs were like 86 or something, so it's been a long time. And this basically says previously adverse modification had to diminish both the potential for recovery and survival of the habitat, such that for it to constitute adverse modification. Now it's either or, because the Endangered Species Act is a statute that promotes both survival and recovery. You want to get the species off the list, so that's important. Another thing is, for years this has been going on, so it's not super new, but it's come up a lot recently with certain species. Is the agencies are trying to find alternatives to listing species. If you list a species, you have to, deal with the act. It makes things a little bit more regimented. Action agencies don't love it, so they're trying to head off the Fish and Wildlife Service from listing species where they can. So, and also the Fish and Wildlife Service has tried to sort of help out in certain ways to offer alternatives. Jamie mentioned the greater sage grouse. That's a huge deal. It's across the western United States. Any oil and gas development out there, renewable energy development, any number of projects will fragment sagebrush habitat and reduce the level of habitat the sage grouse can have. The Ruby pipeline case I brought up, that was we brought this as a NEPA claim because the sage grouse isn't a threatened or endangered species, but the project cut right through the last kind of unfragmented swath of sagebrush steppe habitat, and just in connection with cumulative effects of all the other stuff going on in the area, we felt like this was sort of death by 1,000 cuts. So for the sage grouse, the Fish and Wildlife Service has said we're going to list this by 2015, and the federal agencies led by the Bureau of Land Management have basically said, okay, we're going to try to come up with a plan so you don't have to list it. And so they've come up with this sort of national planning strategy for the sage grouse. The draft came out last year. From what I've heard, it's not great because it's a lot of pieces that don't exactly fit together. You're dealing with sort of like 15 different EISs for one plan, and so it's not really cohesive for the time being, but maybe we'll get there. And finally, you may have heard about this like sort of mega lawsuit that a few groups brought, Wild Earth Guardians and the Center for Biological Diversity, to list a bunch of species that were sort of on the candidate lists and have been sort of cycling through there for a while. And they came up with this settlement where the Fish and Wildlife Service will list 250 of these candidate species by, I think, 2016. And like we discussed earlier, this is a process. It will take some time, and it's going to be a heavy lift for the service, but it'll be interesting to watch.
Yeah, I mean, sort of a good tip is to follow the money. I mean, long been complained is, again, to trigger ESA, you need Section 4 listing, and you need critical habitat listing. They haven't been doing it, not unwillingly, but there's just no money in the budget to do it, and it gets cut. There's not money, there's not personnel. You have to do a lot to list the species, and once it's listed, you have to manage it. And so there are a lot of issues with that. Now, can we give protections to species before they're listed? And that's really, Fish and Wildlife likes that. And you can have these habitat conservation plans actually cover unlisted species now, and it would be like a dormant permit. So this is more and more of, for migratory birds like that. If there's a species that looks, it's a candidate and it's up for 2016 and it looks like it's going to get listed, you could include it in your habitat conservation plan now. And then when it is listed, your project isn't interrupted, because if you don't, then once it's listed, you might be underway, but you have take liability if you don't have coverage for it. So you got to start sort of all over again.
So we got a question from the phone. It's, do you see NEPA and the ESA being used in new ways to combat climate change or other overarching environmental issues?
Mm-hmm.
If so, how?
Mm-hmm.
And so from the perspective of the ESA, yeah, it's certainly one of the things. For one, as I mentioned, environmental organizations have tried this, through certain lawsuits. For example, the coal lease suit I mentioned earlier. It's there's certain ways to try to get at this. Another big one was with the polar bear. Basically, the polar bear was listed in 2008, I want to say, and the Fish and Wildlife Service issued a 4D rule, like we mentioned earlier, that basically said we're listing the polar bear, but you don't have to consult on it with respect to climate change. You can consult on other things. If you're in Alaska, you can look at it. Yeah, and we're only going to consider take to be the definition of take under the Marine Mammal Protection Act. So it very much limited how the polar bear is being listed. They were sort of hoping to head off the fact that groups were really pushing for the listing of the polar bear from the perspective of climate change, and also because the bear is really in a bad way in terms of its habitat. Mm-hmm. So that's been litigated. The Obama administration reissued basically the same 4D rule, I think a year ago, and so it's groups are trying to push the ball forward, trying to use the ESA both to advance the cause of combating climate change, but also addressing the fact that a lot of species are just going to start crashing once we get more into the effects of climate change.
Yeah, I mean, I'll add to that. For under NEPA, there's been guidance in draft form for years now on how do you consider climate change in projects in doing NEPA, and that has not been finalized. So there's your certainty on that, but that's certainly one area trying to standardize what it is and isn't, what climate change is and isn't to be considered under NEPA.
Yeah, that's like 5 years old now, right?
Yeah, it was issued right around the 40th anniversary. It did this whole release of guidance on how to make it better, and that was several of them were finalized on mitigation, on categorical exclusions, but not climate change. That one's not done yet. NEPA has been used creatively internationally. There's a few cases pending and decided involving like the Export-Import Bank regarding coal projects that you finance, financing exports that will go to for coal projects internationally. Does NEPA apply to that decision when the effects aren't here in the United States? It's sort of undecided. I mean, I would say probably no, but it's not settled issue yet. And another thing with ESA is, Adam referred to it. I mean, right now, it's being overshadowed a bit by the greenhouse gas rules that are just released in the Clean Air Act and the Clean Water Act. You may have been following. There's a proposal to expand what waters of the United States are, which would be jurisdiction under the Clean Water Act. Well, there's also multiple proposals under the Fish and Wildlife Service for what triggers ESA. And so the definition of critical habitat is being proposed to be expanded to not just where the animal or plant lives now, but where it ever lived, or where it might live in the future if climate change happens, right? If climate change happens, so northern habitat, that could be so habitat.
Or a higher altitude habitat for
correct,
certain species.
Correct. Yeah. So that would all be inclusive. And then changing adverse modification. So what kind of activities would impact that new broader habitat? And then there's a third one actually that's proposed about redefining a significant proportion of its range.
Yeah.
So what populations and are we looking at? So
got another question.
Another question. Do you view navigation or impacts to navigation a topic in the affected environment chapter of an EA or an EIS? It's not a standard. Think about that a little bit. It's not a standard chapter. I think it would need to understand the project. If, for instance, you were building a bridge, right? One of the big proposals in the current transportation bill is to give more flexibility to impediments to navigation. So you may have a crumbling bridge, but you can't build it under NEPA and the Rivers and Harbors Act because it will have a navigational impact.
Oh, impede things.
Correct. And so what's worse? I mean, having that or having no bridge at all. So there's trying to be some flexibility in doing that. Navigability. Depending on the project, I think it could be part of the affected environment. It could be part of the socioeconomic analysis. I think that's just, we need to understand the project, not necessarily in or out.
Yeah, I think it's
Yeah.
time. Chris says, yeah.
Yeah.
So thank you all so much. Let's give a round of applause to Jen.